We turn to the fourth case on this morning's docket. That's case number 103774, State of Kansas v. Christopher Brooks.
May it please the Court. Samuel Shire of the Appellate Defender Office, appearing on behalf of the appellant defendant, Christopher Brooks. Your Honor, may I please reserve 3 minutes of rebuttal argument?
3 minutes is granted.
The sole issue before this Court today is one of ineffective assistance of counsel. Therefore, the standard of review used by this Court will be one searching for substantial competent evidence to support the District Court's finding of facts. Legal conclusions are reviewed de novo. To establish a claim of ineffective assistance of counsel pursuant to Strickland, Mr. Brooks must demonstrate two of the Strickland prongs. Number one, that his counsel fell below objective reasonable standards, and number two, that because of those errors, there is a reasonable probability of a different outcome for his trial. So, where this case stems from is unexpected testimony. During cross-examination, the victim witness in this case testified that Mr. Brooks had a scar on his genitals. Now, when counsel conferred with Mr. Brooks informed his counsel that he did not have a scar on his genitals. At that point, counsel informed...
Is that in the record? We have that in the record?
That is a factual finding that the district court made on the remand proceeding.
Can I get a clarification when you said it's kind of the spontaneous testimony that led to this whole area of concern? Did the witness testify when she observed the scar? Are we talking about the episodes that occurred 10 years, a decade before trial, 4 years before trial, or the ones that occurred fairly close to when the charges were had?
Well, Your Honor, the questioning was, does Mr. Brooks's genitalia have any distinctive features? The question didn't specify a time period. So the victim's response, as I interpret it, is that generally speaking, Mr. Brooks has a scar on his genitals. Therefore, and this I suppose cuts to the prejudice, but the Court of Appeals opinion seemed to believe that this could be a case where SC was testifying that Mr. Brooks had a scar on his genitals in 2004, but that scar could be gone by now. I believe that her testimony was that generally speaking, he has a scar. And that appears to be the angle that the state took that fact from in its closing arguments. It told the jury, how does SC know that Mr. Brooks has a scar on his genitals unless her testimony is in fact correct, that she was subjected to this abuse.
But what we have is a petition for review by defendant of the Court of Appeals opinion, and the Court of Appeals specifically concluded, consistent with the Green case, quote, that counsel's performance in this regard was deficient, end quote. So we have the first prong of Strickland, and that we don't have a cross appeal on that, do we?
I do not believe so, Your Honor.
So we're really to the second prong of Strickland, not whether it was error, but the second prong.
Yes, Your Honor. And I'd be happy to argue into the error prong at this moment.
If we could focus on that, I think it'd be more helpful for us.
Thank you. Your Honor, essentially this is where Mr. Brooks obviously disagrees with the Court of Appeals opinion. The Court of Appeals determined that there was not a reasonable probability of a different outcome, essentially because SC's testimony was so credible that any attempts to impeach her testimony would have likely been futile. And I believe if you look at the entire record and at the verdicts returned by the jury, that is not the case. Now, Mr. Brooks was acquitted on 5 out of 7 charges. If the jury had accepted all of SC's testimony beyond a reasonable doubt, it could not have acquitted on 5 out of 7 charges.
But not all of those counts involved SC.
Some of them involved exclusively CG.
Right.
However, SC testified that she witnessed, I believe, an act of sodomy committed upon CG. So again, I would submit even there, if the jury believed all of SC's testimony beyond a reasonable doubt, the jury verdict just wouldn't make any sense. So I would say this is a case where the jury clearly had major reservations about the credibility of SC's testimony, and that would make her Yes, Your Honor?
No, so I'm just clarifying. So the CG acquittal is germane because the jury reached that decision despite SC's statement that she saw it occur.
Well, yes, Your Honor, I believe so.
One of the counts involved both girls, didn't it?
Yes, Your Honor, it did. And there was an acquittal on that count as well.
Right.
And I think if you look at the jury verdicts and SC's testimony, what it appears to have happened in this case is that the jury was willing to accept SC's testimony beyond a reasonable doubt to the extent that her testimony was not effectively impeached with prior inconsistent statements or retellings of what had occurred. For example, SC testified that she was subjected to abuse in 2007. That formed the basis of 2 of the state's charges. However, in her initial statement to police authorities, she stated that the last instance of abuse that occurred between her and Mrs. Brooks occurred in 2006. Now, defense counsel was able to use those prior inconsistent statements to impeach SC's testimony at trial, and that appears to have caused the jury to reach acquittals on the charges related to 2007 conduct. So I would submit that if defense counsel had introduced evidence that Mr. Brooks did have a scar on his genitals, that would tend to undermine the entirety of SC's testimony.
That he did not have a scar. If he would have provided evidence of the absence of a scar.
That's correct, Your Honor. I'm sorry if I've misstated myself. But the reason for that is SC testified that this abuse happened over a period of years on a daily basis. So the jury would have every reason to believe that if there were some unusual characteristic of Mr. Brooks' genitals, that SC would have been aware of that characteristic. And by introducing evidence of the scar, or the lack of the scar, that would tend to indicate that the statements SC was making were not factual.
Or even the fading of the scar over time.
Pardon?
Or even if you follow the Court of Appeals thought process that perhaps the scar had faded over time, she, based on the evidence, would have perhaps been aware of the fading of the scar.
That is correct as well, Your Honor. And again, that's the most recent conduct that SC was alleging was from 2007, and this was a 2008 trial. And SC's testimony wasn't to the effect of Mr. Brooks had a scar at one point in time, or from a period of time Mr. Brooks had a scar. Her testimony was Mr. Brooks has a scar on his penis. And that evidence could have been used to impeach her testimony, and by not doing so, it created a reasonable probability of a different outcome for this trial, be it acquittals or a hung jury on the 2 charges that Mr. Brooks was ultimately convicted of.
Do you think the Court of Appeals erred in even talking about the second prong of Strickland? I guess I'm asking because I don't see where the state talked about the second prong of Strickland, so why isn't it just waived?
Well, Your Honor, I would certainly
I know you'd like that answer, but I'm just, why isn't that the answer here? I mean, do you read their brief as arguing the second prong of Strickland?
I don't believe that they argued the second prong of Strickland. I believe it was primarily rooted on that there was no unreasonable error. And to be honest with this court, I am not aware of case law that would help me answer that one way or the other. I would just say that an argument not raised below at an appellate court is usually deemed waived by this court, and certainly it would be appropriate for this court to exercise its discretion in that manner in this case as well. At this point, I believe I have concluded my initial argument, unless this court has further questions.
Yeah, I might. I'd just clarify that we had some general impeachment of the victim, didn't we, with regard to her prior consensual sexual activity, that she had denied it and then subsequently admitted that she had some consensual sexual activity with other people.
Yes, Your Honor, and that would explain...
But that general impeachment didn't affect the jury so much that they wouldn't convict of the 2 counts.
I would disagree, Your Honor. The testimony of SC was that on 3 prior occasions she had intercourse with a person other than Mr. Brooks. Now, I don't remember the exact testimony, but the implication was that this had happened fairly recently in the future, in the past, not in the year 2004. So that impeachment really doesn't cut to the 2004 charges, which Mr. Brooks was ultimately convicted of. And in this case, the jury, in this case, there was simply more evidence impeaching the testimony of the abuse alleged to have occurred in the year 2007. There was not as much impeachment evidence regarding the 2004 charges, and that may well be a reason why the jury ultimately did convict on the 2004 charges, but not the 2007 charges. Here, admitting evidence of the absence of a scar would have impeached the 2004 charges.
Any further questions of counsel? Thank you, counsel.
May it please the court, Michael Gayoso, Jr., Crawford County Attorney on behalf of the state of Kansas. Good morning, Your Honors. I'd like to start out by saying just 2 days ago, I was actually in court with trial counsel in this matter, and I was telling him that I would be defending him today before this honorable court, and I will admit to the court that he did not wish me good luck. With that being said, I think Justice Johnson, you're absolutely correct. There was not a cross appeal as to the issue or the finding by the Court of Appeals regarding the first prong. We are here for that second prong enunciated in Chamberlain, and that being that there would have been that there is a reasonable probability that but for counsel's unprofessional errors, the results of the proceedings would have been different. Furthermore, that a reasonable probability is a probability sufficient to undermine the confidence in the outcome. And in order to do that, this court needs to look at the totality of the evidence that was before the jury.
First place we need to look is your brief. Where do you brief that issue? Because I don't see it. I mean, I've got to be honest with you. I think you put all your eggs in one basket and you lost. And there's only a passing reference on page 25 of your brief about, well, if there's no cumulative error, then there really wasn't any probability of reversal. But, I mean, we knock the defendants out of court all the time on vague references in briefs. And So where do I go in your brief to see where you've argued what you're just about to want to argue orally?
You know, I do mention it on page 7 of the brief. I will admit to you that it is in passing that it is mentioned. Obviously, the first 2 standards are mentioned at the beginning of the issue in the brief. It does mention the district court making the finding that one of the elements was that they would have to show the burden would have to show that the elements or that the verdict would have been different. And I do mention that. I think that's the best answer that I would have for you, Justice Miles. I think with the Court of Appeals, and that's what we're here for, we're reviewing their decision. They looked at all the evidence that was presented in this case. And I know that they mentioned, the Appellate Defender's Office mentions in their petition for review that the court, what they were doing was reweighing the credibility of SC. And that, in fact, it did not occur. I mean, all they were doing is looking at the totality.
Why isn't that an assessment of credibility and a weighing of evidence when they said that she was really credible on other aspects, and then here's some factual things that might have happened. There might have been a fading of the scar. I don't understand how that isn't just classic weighing of evidence, assessing of credibility.
I think what they were doing was looking at the totality of the evidence, which is required.
Well, tell me what other evidence there is that this occurred other than SC's the 2 incidents upon which the convictions were based. What other evidence is there besides SC's testimony?
We had medical testimony from the same SART examiner. She testified at length during the trial regarding the physical trauma that she observed. She said that it ranked in the top 5 of all the examinations that she had. She also said that there was the blunt force trauma that she observed was consistent with non-consensual intercourse, and that the hymen of SC appeared to be that of an adult female. I think all of that is corroborative of what SC stated. I also believe that the sister, I'll use her initials, BG, she testified. And what I found most interesting in her testimony is that she spoke about when she was younger having a crush on her stepfather, and mentioned how he would take her, or he had promised to take her to, I forget if it was Ireland or Australia. SC testified that he had made similar promises to her. And once again, I believe that that is an indicative of this corroboration that the defendant continued to deceive, manipulate this young victim. I think trials are dynamic. Jury trials are very dynamic. You know, I have the opportunity of being there to look at the jury, to look at the court, to look at the witnesses. I cannot even begin to appreciate the position that you're in, looking at a cold record and trying to place yourself in that dynamic of the trial. Keep in mind that defense counsel in this case, at the time that this was tried, had over 28 years of criminal defense experience, had tried approximately 50 jury trials, of which at least four of them were off-grid crimes. This was a very seasoned defense attorney that was representing Mr. Brooks.
But that's all fine and good if you believe that. Why didn't you appeal, or at least on the petition for review, the finding of deficiency? Or do you agree with the Court of Appeals that counsel was deficient?
The reason why it was not done, I did not think of it. It's that simple. It was just that simple. It was cross-appealing. It wasn't in my mindset at the time of reviewing that. And that's why there was not. But I think when you're looking at the totality of the evidence, when you're determining whether or not the probability was changed, numerous opportunities were had of I mean, BG, who had testified she had sexual intercourse, she testified on behalf of the defendant. She testified that she had sexual intercourse, that she has fathered 2 of his children. There was your opportunity for defense counsel, who had called her as a witness, that the jury has heard that, in fact, she had sexual intercourse with this defendant, of bringing this issue in regards to the scar. Additionally, the mother, DH, of these...
Now, I don't
That all
understand that
goes-
argument.
Excuse me.
Sorry. No, go
Excuse
ahead.
me,
I'm
I don't
sorry.
understand that argument that there were multiple opportunities to bring it out, and why doesn't that corroborate the deficient performance when counsel didn't?
Unless it wasn't an answer that they wanted. I mean, I think that knowing how seasoned of a defense attorney this is, and keep in mind, this issue, this sole issue, was mentioned 3 times. 3 times in a 4-day trial period.
If it wasn't important, why did you argue in closing, and I'm going to use the initials instead of the name,
Sure.
quote, "You heard SC, which is unrefuted, describe Mr. Brooks' genitalia, how it was uncircumcised, and how it had a small scar. Unrefuted. How would she know that?" End quote. That's part of what would convince me as a juror. If you're making that argument and it's unrefuted evidence, so it must have been important enough to the prosecution to hang their hat on it.
We did not hang our hang. I would respectfully disagree with that scenario. Just because it was mentioned once, and I believe it was mentioned on rebuttal. I don't even believe it was mentioned during my initial closing arguments. I think it was just mentioned that one time. That's not what we hung our hat on. You know, we relied not only on the testimony of SC, but also of the St. Sard examiner, of also the cross-examination of BG, which was her sister. And Rick Smith, or the trial counsel in that case, really focused hard on impeaching SC. I mean, and he did a great job at doing so. You know, we have a situation where a jury convicted of 2 counts, you know, and I could tell you why that occurred if you're interested. But ultimately, they also acquitted on 2 other counts of SC and all other counts regarding CG. With that being said, this one issue of the scar, and keep in mind, it wasn't just the scar. It was also that the penis was uncircumcised, and that's never been disputed as well. So it just wasn't this issue of the scar. When the Court of Appeal says, well, there's numerous, or there could potentially have been numerous arguments against that, I think what they were doing is that they were just once again looking at the totality of the evidence and whether or not there would be a reasonable probability that would undermine the confidence of the outcome that was had in this case. And I think that's why they were kind of getting into this discussion of...
But setting forth potential evidence that may have refuted the impeachment is not the same as saying there's a plethora of other evidence to support the conviction besides the credibility of the complainant.
It's another way of doing it, sure.
You mentioned the St. Sard examiner, and didn't she testify that she didn't factor in the victim's recent sexual intercourse because the victim didn't tell her about that?
She did, however, she stated that, and I believe that the SC testified that the times that she had sexual intercourse with her boyfriend, which I think there were 3 occasions, I believe, that they were not painful, it was consensual.
But that's a credibility issue again. First of all, there's a credibility issue because she lied to the Sard examiner, who then based her findings on those lies, that she wasn't having sexual intercourse. And so, you know, but now you're asking us to say, well, the jury should have believed SC because she said, well, that sex was consensual and it wasn't rough and this sort of thing. So, I mean, all of this goes back to the victim's credibility. which
No.
you did focus on in rebuttal. You hit it pretty hard.
However, the St. Sard examiner did mention that the occasions, that the trauma that was caused would have been extremely painful, which is not consistent with consensual intercourse. So that, she does address that inconsistency, and defense counsel pointed that out. And further attacked the credibility of SC by bringing up the fact that she did not address it with the St. Sard nurse. But the St. Sard nurse did testify that she would not expect to see this type of trauma to SC had it been a pleasurable, consensual act. With that being said, I typically hate giving up 2 minutes and 35 seconds left of additional arguments, but I will yield my time unless the courts have additional questions for myself.
Would you address what we make of the other acquittals in relation to the Court of Appeals holding that, or rationale of the extreme credibility of the victim?
When you look at the acquittal of CG, there was no medical support. It was her testimony, and there was testimony regarding SC corroborating. I don't believe of the specific instance that CG complained about, other than that one count where there was an allegation that all three were present. There was medical, and I believe that the jury found, because there wasn't medical support of CG, that they had reached a unanimous verdict of acquittal on those counts regarding CG.
But that ties into my question. I mean, the uncorroborated charges, we have acquittals. And the acquittals are because they're uncorroborated and they didn't buy into the victim's credibility. So if what we have before us is a holding by the Court of Appeals that a deficient performance was not reversible because of the credibility of the complainant, but the jury's verdicts contradict that.
But her credibility was impeached. Her credibility was impeached on numerous occasions. We're dealing with one single act of a scar. And I know that you've mentioned, well, we hung our hat on that, and the fact remains it was mentioned once on rebuttal, and that was it. It was let go. We were actually focusing on the St. Sard examiner. We also mentioned the fact of the same stories about going off to faraway places. We talked about SC's consistencies. We focused on her consistencies, while the defense would obviously focus on her inconsistencies. But if you look at all of that, if you look at the totality of the evidence, we would ask the court to affirm the decisions of the Court of Appeals as well as the district court, and find that there is not a reasonable probability that would undermine the confidence in the outcome of this case.
Do we have any further questions of counsel? Thank you, counsel.
Thank you, Your Honors. It's been a pleasure.
You reserve 3 minutes for rebuttal.
Your Honor, unless this court has further questions, I am prepared to waive my rebuttal at this time.
Any questions of counsel? Thank you, counsel. We thank you both for your arguments this morning. Court will take this matter under advisement. This time the court is in recess until 9 o'clock tomorrow morning.
All right.